The state wants to prove that Sarah Boone is a bad egg and had a deprived mind, which is associated with a crime, such as repeated and excessive acts of physical abuse or brutality, or acts that are outrageous, vile, and she had a disregard for human life. The defense will want to evidence that Sarah Boone is a good egg using the limitations of character evidence. This will be interesting because Sarah Boone left her boyfriend in a suitcase whilst playing a game of hide-and-seek when he couldn't breathe and asked to be released. She did not assist him, and sadly, he passed away. So you can check out my playlist on the Sarah Boone case if you want to know the background. And let's hear what her defense is and what they need to prove.
A defense is getting ready to put on its case. The prosecution has rested in the Sarah Boone trial. And one of the reasons they said they are going to call Sarah Boone first is because they are using the battered spouse syndrome and self-defense. And so can you talk to us about what that is and what they basically have to prove to be able to use that as their defense?
Right, under the theory of defense.
So I've paused it just now because we are on day 4 and Sarah Boone did give testimony, and the court has allowed their defense of battered spouse syndrome, a self-defense argument in. Okay, so let's hear what he has to say.
And then usually the state has to prove all the elements of the crime beyond a reasonable doubt. But in this particular case, it's going to be the defense job to convince a jury that there's a history of traumatic domestic violence abuse. And there's case law in the past that recognizes that you can use this defense, but the difference is, reasonable is an imminent fear. So we have to convince a jury now that although there is no imminent fear at this particular moment.
I've stopped it right there again because Sarah Boone has testified that she was in imminent fear, and the court has accepted that there was a scintilla of evidence, which is a legal doctrine that states that even a small amount of relevant evidence is enough to send a legal claim to the jury.
Although there is no imminent fear at this particular moment, there is a history of traumatic abuse that led to Sarah Boone thinking in this particular moment that she had no other option.
So if you're watching day 4, you're kind of wondering, why was the state objecting to this lovely witness that took the stand for the defense? Florida statute allows a defendant to offer evidence related to a pertinent trait that speaks to the characteristic of a defendant, but it must be relevant to the crime or to the defense. Let's watch a clip where the prosecutor objects to the evidence the defense is offering from this wonderful, lovely neighbor of Sarah Boone at the time when she lived with her boyfriend, George. So, and I'll just add some notes as to why I think the judge has allowed some of it and denied some of it. So let's listen to her testimony.
The occasions that you had to interact with Ms. Boone, how did she treat you?
Objection. She was a nice lady.
Overruled.
Nice to me.
Did she ever act uppity?
Objection. Relevance.
Overruled. Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look down on you as a person?
Oh, no.
Did she ever treat you with disrespect?
No.
I'm going to object. This is character evidence.
Sustained.
May I approach on this, Your Honor?
Yes.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No, sir.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No, I can't say.
Did you also observe George Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we're sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Objection. Nomination.
Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yeah.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay. Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Hello.
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
Say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there because we always sit out there.
Right, but we don't know if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for yes or no.
I can tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
Okay. No other questions?
Any redirect examining?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am.
Well, what's your thoughts regarding this testimony? The defense did bring out that Sarah Boone was friendly with her neighbor, Pearl, who saw Sarah's injuries and heard the dogs bark, and assumed her and George were at it on the weekends. Sarah Boone did complain to her, but she could not remember the dates, just that it was when, she heard about it when she was walking her dogs. Sarah would tell her. I also thought the state brought out a relevant point that Ms. Pearl lived 5 doors down, implying, would it be kind of hard for her to hear the dogs barking? What do you think? Do you think the defense on recross should have asked Ms. Pearl, when you lived near Sarah Boone 4 years ago, how was your hearing? Well, of course, the rule of thumb is you would not want to risk asking a question you don't already have the answer to, and that goes for the defense or prosecutor. By leaving a comment, you may help someone else that will read your comment, and of course, I love to read all comments as they are valued, and together we can be more informed, and this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system, and we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.